Good evening, everyone. It is a great honor and a pleasure to introduce tonight's speaker to all of you. Mr. Richard Clayton QC is a well-known barrister in the UK and the joint author of Clayton and Tomlinson, The Law of Human Rights, which has been cited by the Supreme Court, the House of Lords, and the Privy Council on numerous occasions. Richard has conducted many Supreme Court and Privy Council cases and has appeared before the European Court of Human Rights and the Caribbean courts. He has contributed his expertise to the Council of Europe's advisory body, the Venice Commission, in his capacity as the UK's representative since 2011, advising on various constitutional issues in Armenia, Azerbaijan, Russia, Tajikistan, Italy, Turkey, and Slovakia. He's also served as a recorder and is sitting as a deputy high court judge and an international arbitrator. It is against this wide-ranging experience that Richard shares with us his insights pertaining to three most topical issues in the areas of constitutional and human rights jurisprudence in Hong Kong this week. We're delighted to have him with us. Last night, Richard examined judicial review and the freedom of expression, including its impact in a range of contexts, such as on practice and procedure, private law litigation, and in the course of Q&A, we touched on several issues, including the more challenging questions currently facing Hong Kong, pertaining to the advocacy of independence and the impending national anthem legislation, set against the question of whether the same standards would apply in an aspiring democracy with respect to the freedom of expression as they would in a fully fledged democratic society. Today's lecture centers on key concepts in anti-discrimination law, and as with yesterday's lecture, Richard will weave the conceptual and analytical issues into his discussion of recent cases and emerging comparative jurisprudence from all the experience that he brings with him, especially on developments pertaining to same-sex marriage, disability, discrimination, and public housing. Please join me in welcoming Richard.
Colleagues and friends, thank you very much for such a generous introduction. Can I say that I'm glad to see that some people were emboldened to return for punishment a second time, for which I thank you. And it's nice to see some new people have felt like coming as well. I once again also would like to thank you all for having this opportunity to speak on a subject which has a central role in Hong Kong's democracy and governance. I shall be focusing on the equality rights. I shall do that by examining developments in other relevant human rights jurisdictions and discuss their implications. And I take my lead, as I said yesterday, from the approach taken by the final Court of Appeal, reaffirmed in Hassan Development, that the generous approach the Hong Kong courts take to human rights decisions from other jurisdictions. And for these purposes, I am going to talk about cases from the United Kingdom, from the Privy Council, from the European Court of Human Rights, from the United States, from Canada, and Australia. If you'll forgive me repeating a point I made yesterday, but one which is central to my approach to these issues, I believe there is very considerable value when doing human rights work or constitutional cases of examining the case law of different jurisdictions. It seems to me that so many human rights questions are essentially universal in nature, and it's often illuminating to draw upon the collective wisdom emerging from different constitutional approaches to the same issue. Obviously, courts must, when applying comparative legal principles, must be astute to recognize the importance of different legal, political, and cultural traditions. In preparing this particular paper, I have been struck by how active the Hong Kong courts have been in addressing equality rights in 2017, specifically the haircut case involving the activist Wang Kwok-hung. And may I get my apology in first about my way I mangle Chinese. And of course, the two same-sex marriages which are being decided this year, Lun Chuk Kwan and QT. This evening, I shall talk about some key concepts in discrimination law and try and reanalyze some of them through the lens of international jurisprudence, and also look at a few important cases in a few specific areas. Can I say that one thing that struck me, particularly on rereading the screed which I wrote, was that it seems to be that a lot of issues have yet to be definitively determined in the Hong Kong courts, And occasionally I've strayed into discussing the developments internationally, which I think could assist the Hong Kong courts in developing and refining the approach it currently takes. Of course, as you will all know, Article 25 of the Basic Law creates the residents' rights to be equal before the law, and Article 22 of the Hong Kong Bill of Rights talks about that broad issue and also introduces the concept of equal protection of law, which I shall be saying a bit about in terms of its international implications. As you will all here appreciate, constitutional prohibitions on discrimination cover direct and indirect discrimination, and much of this you'll be very familiar with. And it's worth noting that Articles 25 and 22 contain identical non-exhausted lists of prohibited grounds for discrimination. And as I shall explain or develop shortly, the notion of other status has been widely interpreted both by the United Nations Human Rights Committee and by the Strasbourg Court. Now, the first case I'm going to talk about is actually a pretty simple one, which was long hair, who seems to feature prominently in litigation in this jurisdiction, who discovered that he became short-haired as a result of going into the prison system. And he was held in a reception center. Whilst in custody, he was required by the prison officer to have his hair cut. The decision to cut his hair was made pursuant to standing order, which required all male prisoners to have their hair cut sufficiently close but not close clipped. But it allowed female prisoners to have their own choice. He had a very simple case of direct discrimination. As you will all know, the test for direct discrimination is the familiar but-for test. There's direct discrimination if there's less favorable treatment on grounds of sex. It's an objective test, and the courts will generally ask, would the complainant have received the same treatment from the defendant but for his or her sex? So there's no question of justification in direct discrimination cases in general. The intention, motive, and purpose of treating a person is less favorably is also irrelevant. And Mr. Justice O rejected all the Commissioner's reasons he held for rendering Samuel without his haircut by complaining that they really amounted to generalized assumptions, stereotypes, typical assumptions about purported risks associated with male prisoners as a gender as a whole. And I mean, this just was a classic case, really, of discriminatory stereotyping. Moving on to a different topic, I thought it was worthwhile saying a little bit about the concept of other status, which appears in your jurisdiction and discriminatory constitutional instruments. Since the grounds for discrimination are open-ended and refer to other status, it therefore may be instructive to see how the Strasbourg Court and the United Kingdom's courts have treated the meaning of other status, because so far as I can see, this issue has yet to crop up in any definitive way in the Hong Kong courts. Other status has been applied by the European Court of Human Rights in a variety of cases. It's often been interpreted by reference to the French text, which I won't say that because it will show I speak French as badly as I do Chinese. But basically, it's a broad approach. In a Danish case called Kjeldsen, the Strasbourg Court emphasized it has to be based on the personal characteristic, and that has been repeated in many subsequent cases. Personal characteristics don't just mean personal qualities, but can include social characterizations such as marital status, legitimacy, military rank, professional status, trade union status, financial situation, former membership of the KGB, and imprisonment. So it's a personal status which covers a lot of ground. Typically, which is a feature of Strasbourg jurisprudence, the Strasbourg Court has not been very analytical about defining the limits of what it means. It's a court which tends to avoid discursive and abstract analysis of the legal issues it considers. It really has a more continental approach to judgment writing than the discursive common law approach which most of us are familiar with. The issue crystallized to a degree in a case called Clift, which went before the House of Lords, where a prisoner claimed they were subject to discrimination because the Secretary of State's power to reject a recommendation could be only exercised in relation to certain limited classes of prisoners. So his complaint was, well, how come I'm being treated discriminatorily by comparison with those who can benefit from the system? When the case came before the European Court, the Strasbourg Court in Clift in the United Kingdom, the court was asked by the United Kingdom to construe the words other status justum generis, in other words, as taking on the character of its surrounding words, with the other grounds listed in Article 14. The court, importantly, rejected the submission of the United Kingdom on that occasion. It recalls, which is the kind of sort of language Strasbourg likes to use, indeed the Venice Commission, we replicate this, it recalls the general principles that other status has been given a wide meaning. It refers to the case of Carson. Carson, both in the United Kingdom's House of Lords and in the Strasbourg, is quite an important discrimination case. It stated it was unsurprising, I'm at page 5 of this paper, that the court has considered to constitute as other status issues which could be said to be personal in the sense of being innate or inherent. But they accepted that status existed where discrimination does not involve a characteristic which is innate and inherent. And it's not limited, this is paragraph 59 of the judgment, to treatment based on characteristics which are personal in the sense they are innate or inherent. The difficulty, of course, with a principle which is expressed entirely in negative terms is it's difficult to know, what it isn't, but you don't get much help on what it is. But I think the bottom line is that other status is to be construed generously. And that may be relevant to those of you who think or perhaps even run cases in this field. The next general issue I wanted to deal with is a case where, interestingly, the QT, there's some signs of this before QT, but where the QT case really does seem to have now followed the approach taken in the United Kingdom towards discrimination cases. I should have said, that perhaps it's obvious, that like Hong Kong, the United Kingdom has a lot of discrimination ordinary legislation. And of course, I'm not talking about that when I'm referring to United Kingdom human rights. I'm referring to Article 14 of the Convention, which is expressed in not wholly dissimilar terms to the issues that Hong Kong looks at. And one of the questions which has made life unnecessarily complicated when bringing discrimination cases is whether it's necessary for a person who alleges they are the victim of discrimination to identify a comparator who is in an analogous position. And that can be incredibly time-consuming and pretty boring. But the traditional approach has been to identify the comparator to see if their situations are analogous or relevantly different, and then only if they're analogous to consider the question of justification. And the short point is that both the UK and Strasbourg has abandoned that. And then to some degree, it looks like the Court of Appeal and QT have done the same thing. The United Kingdom's approach to Strasbourg was epitomized most recently in a case I discussed at paragraph 21 of my paper, SG, where Lord Reid, who is a bit of an intellectual powerhouse and often gives very impressive judgments in the public law field, looked at the approach that Strasbourg applies in respect of, do you have to look at this question of analogous situation at all? And he points out that in the Grand Chamber in Carson, this is paragraph 67 of his Supreme Court judgment, looks at that says there must be a difference in treatment and an analogous or relatively similar situation, and it is a difference of treatment is discriminatory if it has no objective or reasonable justification, if it doesn't pursue a legitimate name, and there's no reasonable relationship of proportionality. So a violation of Article 14 therefore arises if there's 1, a difference in treatment, 2, of persons in a relevantly similar position, and 3, if it's effectively not proportionate. However, he emphasizes that in practice, the European Court of Human Rights usually elides the second element, the comparability of the situations, and focuses solely on the question of whether the differential treatment is justified. This reflects the fact that the assessment of whether situations are relevantly similar is generally linked to the aims and measures of the question. And he refers to a Strasbourg case called Rasmussen, which is a Danish case. And it's worth looking at that case, which is why I've recited it, because actually it's perfectly clear that you don't need to look at an analogous situation if you read the actual Strasbourg case. It's pointed out by the court. It's about the treatment of a husband and a former wife in the context of Article 8 and the discriminatory treatment in respect to that. The court points out, this is paragraph 22, paragraph 35 of the judgment, that Article 14 safeguards individuals in analogous situations, but it then says the government supported the conclusion of the minority of the commission that they were not analogous. The majority, on the other hand, found the characteristics were not sufficiently fundamental to warrant the conclusion. So there was a split between the commission. At this stage, which is pre-1998, the filtering system of the Strasbourg court was there was a commission of human rights, whereas that's now all changed post-1998. But the key point is what's said, and this is what Robert Reed had in mind in his judgment. The court did not consider, this is paragraph 37, that it was necessary to resolve the issue at all. So it's actually quite an important case, because the Strasbourg court decided self-consciously to duck it. Didn't matter. So the important point is that the UK Supreme Court has deprecated advocates concentrating submissions on whether an applicant can compare him or herself to someone in a relevantly similar position. And that can, in practice, be quite a significant break on the ability to advance a discrimination claim. Now, in QT, Justice of Appeal Poon took a similar approach. He refers to the two-stage approach, which I've set out at no doubt undue length, because I've replicated the judgment. That's just because it helps me remember what I'm talking about. And he goes on to talk about, this is paragraph 99 of his judgment, Carson and Lord Nichols, where Lord Nichols talks about, in some cases it's obvious what the analogy is, in some cases it isn't. Can I commend Lord Nichols' very short judgment in Carson? The great virtue of Lord Nichols is he keeps it simple. And that was actually a thing which he succeeded in doing in the House of Lords in many different fields. He was a truly impressive jurisprudential thinker, but he kept it short, kept it simple. That always seems to me to be a bit of an advantage. So what it comes down to, and it's discussed at greater length in the judgment, is that the two-stage test, you need to look at an analysis, that appears to be gone, subject to the possibility, and I've heard on the QT, so to speak, that this case might be finding its way to the final Court of Appeal, but if I may say so, it looks like a pretty uphill struggle from the government's point of view. Now, I'm now going to turn to proportionality and a case called Yao Yak Lang, which was about charging individuals with the offense of homosexual buggery between men. Again, the position was really pretty straightforward. I think that the burden's on the government to show that justification is satisfied, and where there's a differential treatment based on grounds such as race, sex, or sexual orientation, the court will scrutinize with an intensity whether the difference in treatment is justified. And part of the reason I thought it was interesting to look at this case is that the United Kingdom and the Hong Kong courts routinely rely on what effectively the American courts would call strict scrutiny, where there are suspect categories. Suspect categories are race, sex, sexual orientation, and religion. The question, what tends to happen is that you get into if you're in a suspect category, then a rigorous proportionality test is applied. If you're not in a suspect category, then it's got a manifestly reasonable foundation test is provided with. I'll be saying a little bit about all of that in my last talk on Thursday, and express some views about the Haisan development approach on that question. But the bottom line is that you have really two streams of tests. One where there's a strict test, another where there isn't. I mean, it is possible for even a strict test, even the flexible test to discriminate. I mean, just a case I haven't really mentioned, but it's quite an interesting one. We've had lots of social security issues about, which have gone to our highest courts, about housing benefit caps, or what the government likes to call removing the subsidies, where people, basically, the government decides they should have less bedrooms than they actually have. And the reason I make this point is the most recent offering by the Supreme Court on this issue, where that they use the without manifestly reasonable foundation test, but where the statute prohibited someone from ever being able to establish that they might justifiably get more room, they said that was actually failed even the manifestly reasonable foundation test. Now, the next thing I thought I'd turn to, because I suppose I'm involved in a bit of crystal ball gazing, I suppose, if I can put it like that, is it's quite interesting to note that Article 22 of the Bill of Rights, your Bill of Rights, ensures their right to without discrimination to equal protection of law. So far as I've been able to tell, the Hong Kong courts have only rarely considered the scope of this equal protection guarantee. Due to the assistance of Professor Johannes Strand, he drew to my attention a case called Man Wai Kung No. 2, which was a very old case in 1992, at least probably more seems older to you than to me, but that was about costs in a criminal appeal. But there have been some interesting developments in the international human law field, which I think throw some light on what protection from law, equal protection from law could mean. Of course, it has a very strong and powerful influence in American constitutional law, but that's not what I'm talking about here. Just a sort of small point in parentheses, really. I mean, one of the things which is striking about human rights litigation or constitutional law litigation, I only call it human rights because that's what we call it in England, because as you know, we don't have a constitution, we just have constitutional principles, it's up to a point, is the speed with which events change. And I vividly remember, I did a very interesting Privy Council case called Surat from Trinidad in 2008, where it was all about the government introducing discrimination legislation. And this is often the way in Trinidad, when the opposition came into power, they just didn't implement it. So the question was, what do you do next? So we succeeded in the first Privy Council case in saying, well, the explanation they gave for not doing anything, which was they said it was constitutional legislation subject to a special majority. The submission I made in essence was, that's just tosh. And that did persuade the Privy Council. Interestingly, actually, Tom Bingham dissenting 4-1, very rare instance where he was out 4-1, but everyone else was for us. Anyway, after that, Trinidad, surprise, surprise, did nothing. Because that's the way it deals with things. Obviously, I can't imagine any parallels, but that's the way it deals with uncongenial judgments. So what happened next? Well, 9 months later, we kind of said this isn't entirely satisfactory. So we made, amongst other things, a claim saying we wanted damages for breach of equal protection of law. It was a most extraordinary hearing, really. It was terribly short, which was really weird. And they decided that it was difficult, so they wouldn't say anything, which was really very disappointing. So that was a waste of time. But there has been a recent Privy Council case, and the law in Trinidad has taken it forward as well. And I draw these to your attention because they may merit some consideration by you in terms of possible directions in this jurisdiction. In a case called Maharaj and the Prime Minister of Trinidad, the appellant sought constitutional damages against the Prime Minister and the Cabinet because the Cabinet had decided that Mr. Maharaj should not be reappointed as a member of the Industrial Court to a judicial post. And he was seeking damages on the basis that he hadn't been afforded protection of the law. The language is as good as, it probably is identical, it's certainly as good as identical to the provision that's in the Hong Kong instrument. Much of the argument before the Privy Council focused on the claim that the failure of the Cabinet to check allegations that were instrumental in preventing his reappointment constituted a breach of this equal protection guarantee. And what happened in the case, the judgment by Lord Kerr, or really the opinion actually of the Privy Council, but anyway, that's a boring technicality, but there are opinions rather than judgments. He was seized with enthusiasm on a number of Caribbean cases where he had pointed out that the protection of law provision has developed an expansive approach. In a case called the Attorney General on Barbados, de la Bastide, the president of the Caribbean Court of Justice, said, "The right of protections of the law is so broad and pervasive that it may well nigh be impossible to encapsulate a section of a constitution all the ways it could be invoked." And then the Caribbean Court of Justice took a similar approach in a case called the Maya Leaders Alliance, where it said that the law is evidently in a state of evolution, but we would make the following observations. These are the observations of the Privy Council. The right to protection of the law is multidimensional. Well, if you can work out what that means, you're a better person than me. But anyway, so I suppose you make a matrix. That really is helpful. Anyway, it's multidimensional, broad, pervasive, and it's grounded in fundamental notions of justice and the rule of law. The protection of law prohibits acts of government which arbitrarily or unfairly deprive individuals of their basic constitutional rights to life, liberty, or property. It encompasses the right of every citizen of access to the courts and other judicial bodies established by the law to prosecute and demand effective relief to remedy any breaches of constitutional right. The concept, however, goes beyond these questions of access and includes the right of a citizen to be afforded adequate safeguards against irrationality, unreasonableness, fundamental unfairness, or the arbitrary exercise of power. The right of protection of law may in appropriate cases require relevant organs of the state to take positive action to secure enjoyment of basic constitutional rights. In appropriate cases, a failure to do that may amount to a breach of the right of protection to the law. And the Privy Council said, well, they saw no reason why the laws that had developed in Trinidad and Tobago, the law in Trinidad and Tobago should take a different approach. So they basically adopted this view of a very broad view of what equal protection of the law is. And that point was picked up further in a very recent case in Trinidad last year, which I mentioned in paragraph 34. Protection of the law includes the right to due process. It includes access to the appellate's process, prescribes executive action or inaction from rendering a legal process nugatory, can encompass delay. Now, you might think, if you thought this was at all interesting, that the equal protection of law as developed in the Caribbean, that guarantee may not add much to Hong Kong law, but I'm not so sure that's right. As I understand it, and of course I defer to you because you know much more about Hong Kong law than I do, there's no express right to a fair hearing under Article 35. There are technical difficulties in relation to squeezing out fair trial rights in relation to Article 10, especially in relation to administrative processes. That's the sort of Alconbury point, as we call it in the UK. That's that essentially saying that there's no obligation to provide an independent court when you go through judicial review, unless it happens to be an issue where there has to be a finding of primary fact, like in primary fact in the housing benefit case called Teseo in the United Kingdom now some years ago. Anyway, the reason I digressed into the Caribbean is that it seems to me this is indicative, as is the case in a number of the general points I've made, where because you're at a relatively early stage in formulating your discrimination principles, it may be that there would be benefit from looking at elsewhere and saying, well, if it's good enough for the Privy Council, it might be good enough for us. Now, having completed that bit about general principles, I thought I might say something about the spate of same-sex marriage cases. The first of which, as you will probably, well, I'm sure you all know, but I only recently discovered, the first of which is the important case of W in the Register of Marriages, where the Court of Final Appeal considered a claim by a transsexual who lived and appeared in all respects to be a woman. She and her male partner wished to get married. The Registrar of Marriages decided she wasn't a woman under the Matrimonial Causes Ordinance because there's no power to celebrate a marriage between her and her male partner. She made a claim under Article 37 of the Basic Law about freedom of marriage, under the right to marry, and the right not to be subject to arbitrary or unlawful interference, and so on. The Court of Final Appeal accepted that if the statutory right excluded from the institution of marriage persons whose right to marry could be recognized under the Basic Law, the court had to declare the statutory provision to that extent unconstitutional and to fashion an appropriate constitutional remedy. And that was precisely what it considered doing. I've set out the basic remedial principles put forward by the Australian judge, Sir Anthony Mason, in a case called Lam Kwong Wai, and you can read what I say about that. I didn't say it, they did. But Chief Justice Ma and Permanent Justice Ribeiro took the view that the right to marriage was a strong right. It couldn't be subject to conditions which impair the essence of the right. They looked at the Strasbourg law. They looked at the case of Bellinger and Bellinger, which is the English UK case about transsexuals' marriages, and decided that as a matter of statutory construction and domestic law, the common law Corbett principle, which is that sex has a biological basis, fixed at birth, remained determinative, but that construction was incompatible with Articles, the Strasbourg Articles 8 and 10. They also rejected the argument that the Hong Kong courts could ignore international jurisprudence because of the time they said relevant when your constitutional instruments were promulgated, and basically I've set it out at inordinate length. But the bottom line is they weren't much taken with the government's case. The government lost. Now, what you will also know is that since then, it's not got very straightforward. There was a need, it was said, for the Legislative Council to reconsider the position in the light of the judgment. I mean, in fairness, that's what happened in Bellinger and Bellinger as well, because in Bellinger and Bellinger, the House of Lords said, well, this is actually quite complicated and it requires a bit of thought, and really that's the role of legislatures to do that. So instead of introducing a more comprehensive bill along the lines of the English Gender Recognition Act, which was the act which resulted from the Bellinger case, the government decided to introduce a relatively simple bill, which no one seemed to like very much, one way or the other. So that bill wasn't enacted. And then this raises the somewhat interesting question whether there could be a potential discrimination case brought against the government or the legislature for the failure to introduce implementing legislation. It seems to me, at least, that in principle, there's no reason why a court could not grant an appropriate declaratory relief. However, as you will know, the Hong Kong courts have been careful to modify the range of judicial remedies in constitutional cases. For example, in a case called QZU, the Court of Final Appeal controversially suspended its judgment coming into effect for 6 months. There's a big debate, which is one of those legal debates, which is kind of technically complicated, not hugely interesting in a way, but quite important, is can a court does a court have a jurisdiction to only make a declaration which has prospective overruling, i.e., to keep it simple, what that means, it doesn't apply to the past, but it applies only to the future. The Canadian Supreme Court has held it can prospectively overrule in a case under its Charter of Rights and Freedom. The concept has been rejected in the United Kingdom in a very fine judgment by Robert Walker, called Re Spectrum, actually, and also by the High Court of Australia. It seems to me that the rationale for a court ducking the issue, and this may be, I'm not saying this argument is bound to win, but the rationale for it ducking the issue is less than wholly convincing, because at least 2 points. One is the idea of shaping remedies in constitutional cases to the idea there should be a dialogue with the legislature, which is a very important principle in Canada. Even I've written on that subject, and Lord Bingham was quite enthusiastic about the idea of dialogue. Courts defer, let the legislature get on with it. Well, that principle has not little obvious application if the legislature can't work out what to do. That's the first thing to say. And the second thing, which emerged in an interesting discussion yesterday evening when we were talking about Hong Kong's Legislative Council and its democratic credentials, if I can put it in this way, the argument about deferring to legislation is rather more compelling in a country where it has a fully fledged democratic structure than where it doesn't. I think that's the fairest way of putting it. So it does seem to me that there is scope for a well-formulated, narrowly defined, and very specific form of declaration. Now, when I say scope, that's all I mean. Of course, that may not commend itself to everyone, and it may not be a winning argument. The next same-sex case is Wan Chun Kwong, which is a case from this year. And this concerned a civil servant who entered into a same-sex marriage with a man in New Zealand. And the question was he entitled to the same benefits and allowances that governments give to spouses of other married civil servants, where the marriages were to people of the opposite gender? And then secondly, whether the same-sex marriage is a marriage for the purposes of the statutory construction when construing the Inland Revenue Ordinance. Mr. Justice Chow looked at the approach taken in the Court of Final Appeal. He was taken with some of what Lord Carson said, forgive me, what Lord Nichols said in Carson. The remarkable thing about Lord Nichols' judgment in Carson, it's only 8 paragraphs, but most people are rather taken with it, and it seems to me that's rather a good thing. Mr. Justice Chow, concluded by saying that in some cases you need to look at differences, in others you don't. This is the issue about QT, which I've already referred to. And the applicant argued that he had entered into a marriage which was lawful in New Zealand, and therefore he should be recognized as being married. And that essentially was accepted on the basis that although the special legal status of being married, which is only to someone of the opposite sex, that special status as it exists in Hong Kong law wasn't achievable from the claimant's point of view because Hong Kong doesn't recognize same-sex marriages. But the way he sidestepped all of that was to say this was really discrimination on grounds of sexual orientation, and looked at 2 English cases, well, a District Review Council case from Gibraltar, the Rodriguez case, and Bull and Hall. The government, and I'm going to pick up the speed a bit, gave various reasons to justify, and basically Mr. Justice Howe didn't think much of them, and reached the conclusion that this was discriminatory. Curiously, you might think, he reached a different conclusion in respect of the claim made under the Ordinance, because he thought there was a real distinction as a matter of statutory construction. His rationale isn't entirely clear, and apparently this is under appeal, and there we are. And then the most recent case, which is only on the 25th of September of this year, is QT, where the Court of Appeal considered a policy as applied by the Director of Immigration based on sexual orientation against QT, who is a same-sex partner of her sponsor, SS, in a civil partnership they contracted in England under the Single Civil Partnership Act. The applicant claimed he was subject to differential treatment, and that the government maintained that spouse only refers to a husband and wife in a heterosexual and monogamous marriage, because that's the only form of marriage recognized by the law of Hong Kong. This was a case where the Court of Appeal reversed the first trial, the judgment of Mr. Justice O, and it was argued on behalf of QT that they had been subject to discrimination on three alternative bases, either that all heterosexual married couples benefit from the policy, but all same-sex married couples and civil partners were less favorably treated. Alternatively, it was argued that if the policy was viewed as treating all those who were recognized as married for the purposes of Hong Kong law more favorably than those who were not, they were again being treated unmarried same-sex couples differently. And thirdly, this is actually quite complicated, so if you can't immediately follow it, then you might want to read it later and wrap a towel around your head at the same time. Alternatively, you may take the argument was the policy of granting dependent visas only to spouses, as defined in the policy as a factually neutral policy of general application, placed same-sex couples at a serious and disproportionate disadvantage by comparison with heterosexual couples. So what it comes to is, however you cut it, the Court of Appeal said the claimant had won. They then looked at some various international cases. The principal argument advanced by the director was the policy wasn't discriminatory because it purported to draw a bright line on marriage. That it was going for a hard and fast rule, and that's a sort of legal argument that sometimes commends itself to courts. And that was really the basis upon which it was put. And again, I discussed this at more length, really. But the Court of Appeal would have none of that either. So it's been a pretty substantial and important case. And I understand from brief discussions before we started that it's going to the Court of Final Appeal. Process of success in the Court of Final Appeal of the appeal being reversed, I wonder. And also, I remind myself at paragraph 69 that QT did really put to bed the idea of a two-test analogous situation test, which the Hong Kong courts have been sometimes leaning towards and sometimes leaning against. Next, I'm going to talk about disability discrimination. This is actually really a case mostly on its facts, and I want to try and end relatively soon in case anyone either is awake or wants to ask me a question. It's not compulsory, though. In Law Chi Yun, the applicant suffered from mild-grade intellectual disability. The Secretary of State rejected his application for a native-speaking English teacher scheme, and he brought a constitutional challenge alleging a breach both of the Article 25 of the Basic Law and Article 22 of the Bill of Rights. Mr. Justice O applied recognizable principles. He looked at the question of proportionality. The government argued that the principles from rather broadly. They said that the native-speaking English scheme pursued a legitimate aim of ensuring full-time schemes only available to children where there exist conditions to fully and meaningfully carry out their respective roles under the scheme, that the exclusion of intellectually disabled schools where the level and volume of English teaching falls short is clearly rationally connected to such legitimate aim, and that it was no more than is necessary to accomplish the same. Well, you'll appreciate there are obviously going to be problems on the last limb, leaving aside what you might choose to say about the first two. Mr. Justice O relied on some remarks from Permanent Justice Ribeiro in the Kong Young Min case to the effect that saving costs could not in itself be a legitimate aim to justify restricting a constitutional right, and also found that the saving of costs to exclude intellectually disabled schools from the scheme was not properly explained. Now, the last case I'm going to talk about is, again, really essentially a factual case about public housing and discrimination. in a case called Chan Yun Ming, the applicant challenged the policy of a housing authority concerning the allocation of publicly rented units for divorcees. Essentially, he wanted to retain the benefit of public rental housing unit. Well, you know this much better than I, because there are large differences, huge differences, I say here, between the rents payable in the public sector and a private tenancy in Hong Kong. Justice of Appeal Lam, I think sitting at first instance, took the view that the only question was whether the policy discriminated against the applicant as a divorced person as such. And basically, he had a lot of difficulty about saying that. He tried to argue that the policy discriminated against him because as a party he was the party not given custody. The whole point of the policy was it treated those who had custody of children differently, so that wasn't a hugely convincing argument. He said it discriminated against him as a sitting tenant who wasn't divorced but had the same current level, and it discriminated against him as a divorced person who was able to satisfy the comprehensive means test. Essentially, his complaint was that I don't want to do this test because I'm not going to score very well, so I'm going to be kicked out. And that didn't strike anyone as wholly convincing. I seem to have repeated yet again, probably because the court did, the wondrous words of Lord Nicholl in Carson. Permanent Justice Lam, I don't know, anyways, he decided this case was one of the rare instances where the difference in treatment was obviously attributable to a relevant difference between the applicant and those he sought to compare himself with, but he'd also looked at justification. So the point about the case is that he actually reverted to the traditional test of analogous situation, which I've said it looks as if the Court of Appeal had discarded in the very recent QT case. Okay, so that's where I'm going to draw up stumps. So you'll see that from the equality cases I've looked at, they cover really quite a long period of time, and they do indicate, as lawyers might put it, that discrimination claims are a developing area. In other words, there aren't that many cases which have been litigated here. I mean, it's interesting to compare the number of Hong Kong cases litigated in the past 12 months with claims made under Article 14 of the Human Rights Act. In the past 12 months in the United Kingdom, we've had 2 Supreme Court case decisions, 2 cases of the Court of Appeal, and 3 first instance decisions. And that's, I mean, we're obviously a bigger place, so lots of lawyers dead keen to take cases. So, you know, we do definitely have more of them. That said, on any view that the 3 equality claims before the Hong Kong courts this year on same-sex cases involve issues of fundamental significance. They're important cases. It also, I hope, has been of some value for you to hear some thoughts about how you could look at elsewhere and how principles have been evolved in terms of informing how the Hong Kong courts might look at certain issues for the future. And what, for me, would be interesting to see is just how this whole area of practice progresses over the next few years. Well, thank you very much, and if anyone has any questions, please ask.
Thank you very much, Richard. Let's jump straight to the questions. Anyone? Yes. Could you switch on your mic, please?
So I have a question about other status in the ECHL case law. Because it says here that other status can include things like professional status, trade union status, financial situation, former membership of the KGB, etc., etc. But I'm wondering, I don't really see why the right of equality is engaged in those cases at all. Because surely the point about having some special statuses, like race, marriage, etc., is that society recognizes that those categories are things where people should be treated equally. But I don't think the society really recognizes that former members of the KGB should be treated the same as non-former members of the KGB. Why aren't those cases really cases about justification as opposed to the right of equality?
Well, there are cases about the right of equality. I mean, the first thing to say is that, whilst obviously you're right that there's some types of discrimination which are worse than others, hence we have suspect grounds, you always have to give effect to the actual legal instrument you're looking at. If it makes discrimination on other status, it means exactly that. You've got to then look at what other status means. From memory, I think that the issue about, for example, ex-KGB officers was, I think, a delustration. That there's, in Eastern Europe, and I've come across this a lot through the Venice Commission, there are lots of laws that get passed which basically say that you become a non-citizen if you have certain sorts of connections with the preceding regime. I mean, that puts the point crudely, but that's basically what we're talking about. Now, if you are, in a substantial sense, disadvantaged by virtue of your former job compared to someone else, then that does seem to me to be discriminatory. I mean, the point where I think I agree is slightly problematic, but it's just inherent to the way Strasbourg approaches legal analysis, which is really, it doesn't do it, is that we don't really know what the limits of other status are. But we have examples of where it's being held to be in other status. We're told it's not limited to something, so it's a kind of, it tells us what it isn't, but as I said earlier, it doesn't tell us what it is. And I think what the Strasbourg would say is they would look at it on a case-by-case basis, which isn't hugely helpful, but that's just how it is. But what it does mean, which is I think the key point for the purposes of Hong Kong discrimination legislation and constitutional guarantees, is that it is a broad principle. And that's the balance of play. So that's what the courts, international courts say.
Eric?
Yes, Richard. The Court of Appeal in QT came up with a rather novel and a bit controversial idea of there should be some core rights and obligations to marriage that need not be justified for the kind of discrimination. What's your view on that approach?
Well, I found that, what was odd about that, and you'll have to figure out, but I think that thought was discussed at some length in the first judgment, but wasn't really picked up by Ribeiro and the rest of the judgments. It wasn't clear to me, because it wasn't very developed, how that was supposed to fit in. And if I can express a prejudice, which I indicated when I talked about Carson, I think there are huge advantages in keeping the law simple. I'm not convinced necessarily that the Hong Kong judiciary set out to achieve that all the time, but I don't see why introducing a category which takes people outside the orbit of a right or not, which has no foundation in the wording of the instrument, really helps. So I don't find it particularly helpful to say that there are some core rights and there's some less core rights. The thing which I find particularly odd about the statement to that effect was it wasn't obvious to me necessarily that the core right was in play in the case itself. I couldn't quite figure out what's core and what's not. I think the best way of looking at it is it's a principle which is ripe for refinement, if indeed it's going to go anywhere.
Janice?
Thank you, Rick. I have some difficulty with that inherent suspected grounds as well. And the way it works is that certain categories are inherently suspect and more rigorous scrutiny has to be adopted, whereas if you not fall into that, less stringent scrutiny will be adopted. The American experience is that as a result, you shift the arguments from the impact of discrimination to the classification of the grounds. So is it within the suspected grounds, and if you can manage to turn some grounds into a suspected managed ground, you are bound to succeed. Whereas if you are not in the inherent suspected grounds, you are bound to lose almost. And that's the danger that by adopting this category of inherently suspected grounds, and which makes it more difficult once you're not in that area, like what you have suggested, criminal record, is this a suspected grounds? Residence, is this a suspected grounds? A lot would depends on what are the impact and so on. But then the court seems to be very much adhere to this concept of suspected grounds and so on, although not as extreme as American. But then if you fall outside these inherently suspected grounds, it's more difficult to succeed. I'm not sure whether that is the experience in UK. And the other part of the question would be that you have talked a lot about direct discrimination. Whether you would like to say something about indirect discrimination, which looks like more difficult to succeed.
Yeah. Well, dealing with your first point about suspect grounds and so on, I mean, the bottom line is that, I mean, in many ways, the Americans' jurisprudence originated and developed discrimination law principles. And I think the position is it's so firmly established that that categorization isn't going to change. That's the first thing to say. The second thing to say is that although it results in a kind of very significant divide between applying a strict test on the one hand and a really something perilously close to a rationality test on the other, although that's what it looks like, I mean, I suppose one thing that one could say is that proportionality ought to be context-related. In Daly, Lord Steyn memorably told us that in the law context is everything. So it may well be that in cases which are on the penumbra of suspect grounds that you would apply a stricter test. But I do think that it's a distinction which certainly, so far as the UK courts, is not going to change. And I'm afraid my grasp of Hong Kong discrimination law isn't sufficient to be authoritatively express a view, but my sense of it is that it's here to stay irrespective of its intrinsic merits. As to indirect discrimination, it's worth saying that, I mean, indirect discrimination is obviously hugely important. It looks at the effect of disparate impacts. I mean, having first written a very long book now some long years ago, at that stage, Strasbourg had only just begun to recognize that there was a concept of indirect discrimination, a Greek case, which I'm as bad at speaking Greek as a Chinese or indeed any other language other than possibly English. But that was a case about the treatment, the way a Jehovah's Witness was treated in terms of declining to conscription. But the point about it is that, in a sense, it is very important. I'm sure it's familiar, the principles are familiar, so I don't need to repeat them to you. But I think what it does illustrate ties together with the point we were discussing a minute ago, which is that because the United States led the way, really, on discrimination law, Europe has been a long way behind, although the EU, of course, radically altered that in terms of equality legislation. And of course, that's one of the impacts for us of the Brexit, is that all the rights conferred, which of course trump English statutes as a result of EU law, that will all go. It may all go if we ever leave Brexit. But I certainly wasn't focusing on direct discrimination, seeking to say anything other than anything to the effect that indirect discrimination is unimportant. In fact, in many respects, it's more strategic, has a broader implications, and is hugely important.
Eric?
I will ask again, just follow up on this indirect discrimination. Assuming that QT and Leung Chun Kong, the decision was upheld on further appeal, the effect is that those who got married or a civil union elsewhere could then get the same benefit as a married couple in Hong Kong. Could then be a further argument that that would be discriminatory to those same-sex partners in Hong Kong who cannot afford to go elsewhere to register their relationship? Do you see the argument here?
I do see your point. Well, I mean, one of the problems with lawyers is that it's easy for us to find differences fairly readily. You might be formulating a kind of piggyback type legal strategy where you win on one point and then you say, well, actually, where we've ended up is itself discriminatory, so we need to move on. But I mean, you're perfectly right that the answer given gives rise to what lawyers might or judges might call anomalies, which call for justification. But I mean, you know, if that demonstrates anything, it may just demonstrate that cases are sometimes quirky and judges can never answer every question at the same time. I mean, the cases are always limited to the application of the principles to a particular set of facts. But you may be pointing your finger and saying why, assuming everything is hunky-dory, that that you'll end up with equality rights of a wholly different character for people in Hong Kong for 10 or 15 years on. That may be a result. I'll leave it to you to bet as to how certain that outcome is.
I'm going to take advantage of being chair and just ask you the last question perhaps for the evening, if that's all right. So I think following on from Eric's point, if you look at the 4 anti-discrimination ordinances that we have in Hong Kong, it's quite clear that actually the last one we've just implemented, which is the racial discrimination ordinance, is substantially weaker than the other 3 anti-discrimination ordinances. So do you suppose that there could be an argument, drawing on your equal protection before the law principle that you alluded to say that as a category, racial groups, therefore, or the groups covered under the race discrimination ordinance, are afforded a weaker form of protection under the law, and therefore that in itself is discriminatory as between classes who fall within the protected grounds?
Well, I think that's a very interesting thought. I mean, that may be true. I can't help feeling that at some level or another, the underlying policy to justify the difference of treatment would have to be looked at by a court. And it depends on how enthusiastic the courts are to enter into what some lawyers think is forbidden territory. But I can't help feeling that it would be difficult to imagine a court not asking itself whether the difference in treatment was proportionate. So I think the argument is entirely sustainable or better than that. But I don't think you could sidestep the $64,000 question, which is, why was the legislation introduced which is weaker, and can the government justify a weaker? Now, it won't always. I mean, to choose a completely different example, but a case which was simply extraordinary when Conservatives were in power in 1995, we had 2 juveniles who murdered a boy called Jamie Bulger, and they were subject to a lot of litigation. Well, one of the things which the Home Secretary did was, in deciding that he'd send them away for a long time, is he relied on a poll run by the Sun newspaper. And the House of Lords weren't especially taken with that as a way of sort of sampling opinion. So, it may be that there are instances where it is hard to justify. But, I mean, ultimately, one gets caught in very difficult questions in constitutional law because where are the proper tram lines or boundaries between government and courts is probably a conversation which we could carry on for the rest of the evening.
Absolutely. Well, thank you so much for such an incisive analysis of Hong Kong's journey through equality law, and I'm particularly excited about sort of the gaps that you've identified and the potential for how the jurisprudence might develop going forward. It's been immensely beneficial, and I'd like everyone to please join me to thank you on behalf of CCPL and the faculty.